If you haven't checked in for attendance yet, continue after class, otherwise you will be absent.
Yeah.
Reminder, we're having a makeup class on Sunday. I don't like doing these, but we have to. So if you can't attend, you can watch it at your convenience online, but please notify me within a week that you watch it to certify it by attendance. Our last Sunday class, about 6 or 7 of you came, which was better than I expected, but almost all of you watched the video, which I do appreciate. Okay? Any questions about that? Or any questions or anything else? All right, turn this off. Okay. I'm sorry, yeah.
I'm sure you've said this before, but to that detail, when would we expect to have midterms graded?
Oh, yes. So the midterms will be graded by the end of the month.
Oh.
Yeah.
Nice.
No. So the way this is going to work, I think I mentioned before, is throughout the entire month of November, I am meeting with every single one of you. You don't know yet, but I will. I will circulate a link probably next week or the week after, ask you to sign up for a time slot. It's going to be a 30-minute slot. I will make available about 115 slots between now and the end of the semester. That's for you and my other section. You'll find a slot that works for you. There'll be something. It might be late at night, it might be in a weekend, but I promise there'll be a slot for everyone. And the purpose of these meetings is to meet with me one-on-one to figure out what you did right, what you did wrong, and how to correct action. If you work with me, you can do better. If you blow this off and don't take it seriously, you won't. So I will grade all the midterms by the end of this month. Before the meeting with me, you should review your midterm, compare it to the A+ answer, and be ready to talk about it. This happens every year. Someone shows up for their midterm review session, they don't have their paper with them. If you do that, I'll send you away and say, come back another time. That shows you're not prepared. People show up and say, oh, I haven't reviewed my paper yet. I will send you away and say, come back another time. So please take this seriously. It's a significant time commitment, but one I care about deeply because I want you to have a time to meet with me. It's a strange thing of law school that usually the only feedback you get is your final exam, right? And at that point, you don't care because the class is over. I think it's mistaken, and we're trying at South Texas, and Dean Jenkins will, former Dean Jenkins. Can I still call you Dean? You're still Dean, right?
Still Dean.
So I call it
What's Dean always Dean?
always Dean. And Dean Jenkins and others have made this, I think, a fair point that we should be giving you feedback early on in the semester before you get your final exam, and that way I can correct you. Now, I tell you this, most students, what you score on the midterm, that will be your final grade, I promise. Most people don't move. Some do. Some move up, some actually move down. But if you want to be the people who move up, you need to work with me, okay? That answers your question?
Yes, thank you.
But I'll get it done by the end of the month. I only have 100-something students this semester. I usually have about 150, so it'll be a little bit easier for me. Yes, Crystal?
Where will we pick up on exams?
From Cindy, she sits across the hall from me. I'll email you when they're ready to pick up. It'll be no later than the end of this month because I want to start the reviews by November. So at some point this month, I don't know when, maybe it'll be earlier or later, but I haven't delved into the stack quite yet. It's stacked pretty high. Yes, sir.
Is that also when you'll post the A+ answer?
Yeah, I will post the A+ answer as soon as it's done grading. So you'll be able to compare yours immediately. And the reason why I give you the A+ answer is I want you to see how one of your colleagues did it. Not like what I can do, because I know the exam, I wrote it, but one of your colleagues, how they performed under time and under stress. And I take it, there were no frantic emails that I got stuck in traffic and I had a car accident, all of you made it. And if you didn't, good for you. But everyone who I think took it, then took it well. Is there any other questions about that? Any other questions about the midterm? We'll talk about more when I actually get around to grading and see how you guys did. Okay? All right. Here's your question for today. The framers of the 13th, 14th, and 15th Amendments intended those provisions to protect the freedmen. What's your question? The framers of the 13th, 14th, 15th Amendments intended those provisions to protect the freedmen. That's your question. Vote. Okay, true or false? 20 seconds or so. About 10 seconds. Five seconds. All right. Portland, are you next? No, who's next? Yeah, Cortland, I'll go with you. Start there, right? Okay. What'd you put? True or false?
True.
Okay. Why do you put true?
Does freedmen mean the, like, slaves?
Yeah, the freed slaves, exactly.
That's just what I know that in the majority of the slaughterhouse case, I don't think you agree that it was just for the freedmen.
Oh, it doesn't matter what I think.
But that's just what I thought when I read it.
Okay. Mark, what'd you put?
False.
Okay, why'd you put false?
I guess it was Thomas's opinion throughout McDonald, which turned me.
And what turned you? Why did you change your mind?
Well, I just felt that he gave enough of a description to indicate that it was not only.
Only.
Intended.
So I framed the question very deliberately, right? Did I say it was only intended to protect the freedmen? How did I frame the question? You added a word, I think it's a very good word. You added the word only. So, what do you think?
Looking at the question the way that you just described it, then I think that they very much did want to make sure that there weren't advantages that were taken.
But I'm glad, I try to frame these questions as precisely as I can. I think Mark read more into the question than I actually did. Chris, what's your answer?
I put false.
Okay.
I put false because my interpretation of it was that it was intended to protect the people who were not free. So it was intended to protect the people before they were freed.
Okay, but was it limited to the freed slaves? Was
I
that
think
their
that
intent?
was the intention of it initially, yes.
All right, Eric, what'd you put?
I think the initial intent was just the freedmen specifically because I think that was what was on the minds of the people who were enacting the legislation at that time.
Okay.
So they're specifically trying to do a specific thing at that time.
Did they intend anything else beyond the freedmen?
Well, I think those people that are sitting in that room would somebody would have brought up, you know, these things could be misconstrued as, or not misconstrued, but construed as.
I was about to jump on you for that one. Yeah.
Right. Construed as something else other than protecting freedmen, like we talked about protecting corporations and things like that.
So, Martin, let me ask you this question. Let's actually bring up the text of the 14th Amendment, right? And we can read this text, right? Is there anything in the text of the 14th Amendment which suggests that it's limited to the freedmen?
Not at all.
Not at all. Does it say all freed slaves shall receive protection?
No,
Does it say the freedmen shall get due process of law?
It says all persons.
Persons. All men? Say all men?
Does not.
Persons. So I think what we have here with the 14th Amendment is from the earliest of times, there was a debate. Eric, Crystal, Mark, you guys are making debate. What was the intent of the framers versus what is the meaning of the language they actually used? And if we limit ourselves to what the intent of the framers is, I think Eric and I think Cortland are probably right that their intent was to provide protection for the freedmen. We just fought a civil war over slavery, and they were trying to provide protection for the freedmen. But if you read the words that they wrote, the words they actually used, it's not so limited. The words they used have far greater reach than simply the freedmen. And you're right, it says persons, not men, not women. Let's see what the results were. Curious. Wow, okay, so that's 70% of you put true. Okay. The 70% of you that put true, that's probably reflected in the majority of Slaughterhouse. I think someone said that. That this was only about protecting slaves. But if you read the dissent in Slaughterhouse and also Justice Thomas's opinion in McDonald, the answer seems to be false, I think. Yes, ma'am.
Well, I guess you kind of covered it, but I saw it as false because didn't they state that the terminology used was very general?
That's what Martin said, right? It says person. Let's say Freedmen. Because you had legislation, right? The Civil Rights Act, the Freedmen's Bureau Act. There were pieces of legislation that named the freedmen. Like it was specifically applying to certain people who were freed slaves. But the 14th Amendment doesn't use that language. So if you're a judge, right, and you're interpreting the 14th Amendment, what do you go with? The intent of the framers? Or what the meaning of the words they chose were? What did they intend based on statements they made during the ratification process? Or how would a random person off the street understand those very provisions, right? These are tough questions that the justices, at a very early time, resolved, as 70% of you did, true. So when you read the cases for today, Slaughterhouse, Bradwell, and you read the cases for next class as well, civil rights cases, they read it awfully narrowly. And the decision to read the 14th Amendment narrowly drastically changed the course of our republic for much of the 20th century, right? If you limit yourself to the intent, you get one answer. If you look at the meaning of these phrases, I think you do what Justice Field did in dissent and get a very, very different answer about the scope of this amendment. Okay? All right, so any questions on this kickoff question? Actually, that was about what I expected. I thought it would be a little bit closer to 60-40, but close enough to what I expected. Yeah, Jason?
Do you think they chose this language because of the ratification process?
What do you mean?
That when a constitutional amendment doesn't have it's not just they pass it to Congress, it goes to the states.
Right.
And so perhaps it was language that would be more appealing to a state legislature.
Well, which states at the time may have opposed this?
The newly brought back southern states.
So here's the rub, right? You need 3/4 of the states to agree to the amendment to ratify, right? During the Civil War, the southern states were basically thrown out of our government, right? They had their own government, we had ours. Actually, Texas, theirs, whatever. But the point is, for many of the southern states, their admission to the Union was contingent upon ratifying the 14th Amendment. So they didn't have much of a choice. And in fact, you look at these fringe conspiracy theorists say, the 14th Amendment is not valid because it was ratified against their will. Okay, we'll put that aside for a moment. But they chose this language, I think, Jason, is not something to have a very general application. Because maybe they didn't know all the context in which this would arise. And generally, when you write a constitution, you use broader language because you don't know its specificity. And it can't be changed the same way you would change a statute.
Well, I was just gonna say that I think the broad language that they used was a way to prevent them from justifying denying rights to these people because they didn't fit a certain definition.
So if they said the freedmen are guaranteed equal protection of the law, right? What would that mean, right? How would you define that?
It would mean specifically people who used to be slaves.
And what about newly born people?
Excuse me?
Would newly born people be subject to that?
Exactly.
Okay, so the use of the word persons, right, maybe was designed for the context Andre said, but the word person is still pretty broad. There was a famous story involving Susan B. Anthony, right, the famous suffragist. And she wanted to vote, right, and the states at the time didn't allow women to vote. So she actually went up to a polling precinct somewhere in New York, and she took out her constitution, which we all have, and she said, it says, nor deny to any person the equal protection of the laws. She's like, I'm a person, give me a ballot. And she actually got a ballot, right? The guy gave her a ballot. The vote didn't count. They eventually nullified the vote. But the language used, at least in Section 1 of the 14th Amendment, is broad enough now. We know in Section 2 it says the word man, doesn't it? Yeah, there's a note about that. So there was an addition of the first time, a gender pronoun, a gender noun into Section 2. Okay. So any more questions on this? right, let's do the first case, slaughterhouse. This is probably one of the most important Supreme Court decisions you've never heard of. This decision from 1873, 5 years after the 14th Amendment was ratified. So I want you to think about this for a minute, right? We're sitting here in 2017, 150 years after the 14th Amendment was ratified, right? 150 years. We're still unsure what the thing means. Here, they're in the year 1873, 5 years after it was ratified, right? 5 years. And even then they don't know what it means. This, I think, highlights one of the difficulties of interpreting constitutional texts, where you have these debates over meaning that are, 150 years old. Okay? Ashley, you want to give us the facts, please, in Slaughterhouse?
So Louisiana, it's in Louisiana, and the legislature passed an act that required the slaughterhouses to only slaughter the animals in one specific location.
Very good.
And so the butchers, and they had to pay a fee, and so then the butchers sued that this was unconstitutional.
Okay, very good, thank you. Today we don't think much about health and safety laws, right? There are so many health and safety laws, it's part of our world. But in the 1870s, this was a fairly novel idea. The notion that the city would put restraints on how butchers performed their profession was considered outrageous. Now, here, this wasn't a law that regulated how butchers should keep their shops, how they should keep cleanliness, sanitation. Instead, they did something else. They said, if you want to slaughter an animal in the city of New Orleans, you have to come here to the slaughterhouse, the Crescent City Livestock Landing and Slaughterhouse Company. This was the only place where you were allowed to slaughter an animal. Once you slaughtered it here, you could bring it back to your shop and chop it up, whatever, but the actual act of slaughter, right, had to happen in this one facility. And, oh, by the way, to pay a fee. Now, who owned this? A company, right? What do we call this? A monopoly, right? The government gave a monopoly to this one firm that operated the New Orleans slaughterhouse. Okay? Everyone understand the facts, right? One company had a complete monopoly. So if you had your own butcher shop where you would slaughter animals, it was now illegal for you to do it in your own shop. You had to go down to the central location. Now, was this actually a measure motivated by public safety concerns? Anyone from New Orleans here? Not one from New Orleans. Anyone Louisiana? Oh, that's a first. Well, let me put it this way. Corruption and New Orleans government goes way back. Cronyism, right? This was, in large measure, a law to give a monopoly to a certain segment of the industry. Had the city wanted to impose restrictions on health and safety, they could have done that. But instead of having inspectors go inspect, just come here instead. Okay, so this law was enacted. You're a butcher, and you want to challenge this law. So, Emily, before the 14th Amendment, if you want to challenge this, what would you have to have done before the 14th Amendment was ratified? How would you have to challenge this Louisiana law?
I think they said it was the privileges and immunities.
Before the 14th Amendment. 14th Amendment has not been ratified yet, and you want to challenge the constitutionality of this New Orleans law. What would you have to use?
Due process.
Oh, of which amendment?
Fifth?
Does the Fifth Amendment due process clause apply to Louisiana laws?
No, it doesn't apply to state.
Why not?
Because it doesn't hold the state.
What case is that? I hope you got this for the midterm. There's a question in the midterm. Barron.
Yeah.
Barron v. Baltimore. In fact, that was a question in the midterm, by the way, whether the restriction on the states for the takings clause, hope you guys got that. So the question is, yeah, see? Somebody got it, which is good. The question is this: before the 14th Amendment, could someone challenge this law, this New Orleans law under the federal Constitution? The answer is no. Because before the 14th Amendment, state laws were basically uncontrolled by the Constitution. They couldn't be ex post facto laws, they couldn't abridge contracts. There were a few things which specifically control the states. But like Justice Marshall said in Barron v. Baltimore, the Bill of Rights, the first 8 amendments, do not control the states. Okay? Everyone with me so far? So before the 14th Amendment, a state's police power was basically unlimited, right? The state could do whatever they wanted with respect to the health, safety, and wellness of the people. There was no restrictions. So the question is this: was that changed by the 14th Amendment? Did the 14th Amendment merely protect the freedmen? Or did it impose new restraints on the police power of Louisiana? That's your question. Did the 14th Amendment impose new restraints on the Louisiana government? And could those restraints be enforced in court? Everyone see the question, right? So we look at our 14th Amendment. I broke it down by clause here, right? Section 1 of the 14th Amendment. So the first provision is not really relevant here, right? It's very important, but not relevant to this case. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. This, as we discussed last week, was an express repudiation of Dred Scott. That by the mere act of being born in the United States, whether you're black or white, you are now a citizen not only of the United States, but of your own state. Of your own state. And you can use diversity jurisdiction if you wish, but you are a citizen, right? So that's section of the first clause. The second clause is one which we'll focus on extensively today, which is the privileges or immunities clause, right? Please do not confuse this with the privileges and immunities clause. Please don't do it. The privileges and immunities clause is in Article 4 of the Constitution. The privileges or immunities clause is in the 14th Amendment. You can remember this because privileges and, like letter A, that comes first in Article 4. Privileges or, O comes after A, is in the 14th Amendment, so don't forget that. And this provision states, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So what's the most significant change between the first 10 amendments and this one? Why is this clause so significant? What's new about this? Why is there such a significant transformation of our polity, or is it? Maybe it's not.
I was gonna say maybe the first 10 amendments don't talk about the privileges.
Oh, so you got it there. What are the first words of the First Amendment? Open the Constitution, read it. What are the first words of the First Amendment? I thought you were going there, but you deviated the last minute. What are the first words of the First Amendment?
Congress shall make no
Stop.
law,
Okay. And what are the first words of this provision?
no state.
So what's the big deal, right? What's the big shift from the First Amendment and Bill of Rights to this?
That we're not talking about the federal government, now we're talking about the state government.
Exactly. Everyone see that. Everyone who we just said, he's exactly right. The big shift of the 14th Amendment from the Bill of Rights is that now restrictions are put on the states, right? That's new. That had not been done before. There were some states can't pass ex post facto laws. States can't violate contracts, right? Some fairly rinky dinks, actually contract laws was important, but by today's standards it's not very important. But now we're going to be applying these 3 new provisions directly to the states. And the first one says that the states cannot make or enforce any laws which shall abridge the privileges or immunities of citizens of the United States. And I want to dwell on this for a minute. The states can't make or enforce any law. Kelly, what's that mean? We already did the first two words, let's do the next four words, right? What does it mean that the states can't make or enforce any laws? What's the limitation here? What does it mean that a state can't make or enforce a law? What is that doing? Read it. Well, what does that mean? A state can't make or enforce a law?
I'm just reading it as blatantly as it is.
Okay, and what does that mean? A state can't make or enforce a law? What is that doing to a state legislature?
Minimizing.
Ah, exactly. It's telling the state, hey, you want to pass this law? You have the votes. The governor wants to sign the law. Too bad you can't, right? This is making a direct limitation on the legislative power of the state. A direct limitation on the state's legislative power, right? They used to be able to make this law, right? Whatever the law is, they could have done it before, but they can't do it now. Everyone with me, right? Everyone with me so far? Everyone agree? Okay, good. So China, let's go to the next clause. Which shall abridge the privileges or immunities. Stop right there. What is that telling states that they cannot do? Okay. They can't make or enforce any laws that intrude on these rights. Now China, here I'll give you the tough follow-up, you got an easy one to start. What are the privileges or immunities? How do we know what these things are? It's up there, that's all you got, right? If you're a legislator in New Orleans, right, and you want to pass a law, how on earth are you supposed to know what these privileges or immunities are?
It could be amounted to anything.
Was this a very helpful instruction to state governments knowing what they can and can't do? No. Well, I think it actually was very helpful, but by today's standards, it's not. You're telling states you can't do stuff, right? You can't pass laws that violate these privileges and immunities. We're not going to tell you what those are, but you can't do it. Then jail. Who then does it fall to define what those privileges or immunities are? If it's not defined, this is it. The text is right there. That's all you got. Who then does it fall to define what those are? Does it say that? Does it say the courts get to define it?
Yeah.
Who does? Why do you think? I think you might be right, but why do you think the courts?
Because the courts are what interpret the law.
Well, I forgot to put it up there, but turn to Section 5 of the 14th Amendment, right? It's on page, where is it? It's at the top of page 76, right, of your Constitution. Lazari, you have it handy? Oh, come on, John, you have handy. Page 76. Read section, I'll come back in a second, Lazari. Read Section 5 of the 14th Amendment.
The Congress shall have power to enforce by appropriate legislation the provisions of this article.
Ah, so I asked Jay a minute ago, who is responsible for interpreting what privileges or immunities are? She said the courts. She might be right. I think she's probably right.
Congress can enforce the provisions, but that's not, I guess that kind of entails, it's implied that you have to.
You know what case I'm thinking about, don't you? What case am I talking about? This is a good midterm review. What case is this exactly talking about with Section 5 powers? And who gets to define the Constitution? You should know. What? Not Marbury. No, more recent. Much more recent. What? Say it?
McCullough?
No. Very recent. Section 5 case, last 20 years. Did really early on this semester. What? What? Who said it? Bernie. Who said Bernie?
Someone up there did, I just said it.
Bernie. Tell me why it's Bernie now. That's the hard part. Why is Bernie directly relevant here? The language says Congress shall enforce provisions. Zach?
Was it because Congress tried to expand the provisions and they tried to say what was protected under?
Congress tried to define what the First Amendment meant. Remember that? The Supreme Court in Bernie v. Flores said you can't do that. So here, this question with Jay and John, I think is a very good example of this, right? it doesn't say the courts get to define what the 14th Amendment is. In fact, it says Congress shall enforce this. And certainly one of the ways it can enforce it is by defining what those privileges are. So it's not automatic that the court gets to be deciding what these privileges or immunities are, although that's invariably how I think Jay is right. In a matter of history, it turned out that way. But there's a provision here that says Congress can do it. In fact, it's not even entirely clear if the 14th Amendment was meant to be enforced by the courts or Congress. Because Congress thought it would be passing all this legislation to protect civil rights. And that the 14th Amendment, maybe by itself, would not stand alone. But the language doesn't answer one way or the other. So again, regardless of what their intents may have been, the language is not so constrained. I think Jay's interpretation is entirely consistent with the text, that the courts then have to decide what are these privileges or immunities. By the way, sorry, I wasn't meaning to abridge. We'll go to the next word. I highlighted too much. What does abridge mean? Abridge. Not like the cross water, right? What's a bridge? Violate, maybe?
Yeah.
Does that mean that these privileges can never be violated in any circumstances? All right? The Second Amendment, the right to keep and bear arms shall not be infringed, period. First Amendment, Congress can make no law abridging the freedom of speech. Does that mean no law at all? They can't make any law affecting speech? Is that what it means? So what does abridge mean? Yeah, you're next.
To limit or to?
Can they limit anything they want? Make any limitation? They can't make anything.
Well, I would think that based on what you said, to abridge, it would be to contradict, to contradict what, for example, what I'm thinking is the supremacy clause where a state law cannot contradict federal
Okay,
law.
look, so
Not
First Amendment, right? It says Congress should make no law abridging the freedom of speech. No law. And this is similar. No state shall make any law which shall abridge the privileges of immunities. Does that mean Congress can never regulate speech? Ever, ever, ever? That's not what it says. Because it can't make any law. It can't make no law, right? Okay, so what I'm getting at here, we haven't done the First Amendment yet, so it's a little bit unfair, is this. The courts have interpreted shall not be infringed and shall make no law. It's a little bit looser, right? That they can have certain restrictions on speech and certain restrictions on arms and certain restrictions on privileges, but, not absolute. So the courts have read into this language, which shall abridge as almost a balancing test of sorts, right? They don't take this absolutist approach to constitutional rights. All right. Rachel, let's go to the last part. What does this mean? No state shall make or enforce any law which shall abridge the privileges of citizens of the United States.
Yeah, I think
What's this last provision about?
it's interesting that they don't write citizens of the respective states.
They don't write that.
You're right.
What do they write?
So I think that it's almost showing hierarchy.
Hierarchy, okay, what do you mean?
Well, so the citizens of the United States are controlled by the federal government, so they have the protections of the federal government.
Okay.
If Congress can't make a law that abridges a person's right, then neither can the states through the 14th. If that makes sense.
Now, let me ask a follow-up, Rachel. Who are the citizens of the United States? And let's scroll back up to Section 1, the first clause. Who are the citizens of the United States?
All persons born or naturalized in the United States and subject to the jurisdiction thereof.
Is there a difference between being a state citizen and being a citizen of the United States? Section 1? Can you be one and not the other?
No.
Can you be a state citizen but not a citizen of the United States, or the other way around?
No, if you are a United States citizen, you are also subject, or you are also a state citizen.
So let's go back to this clause right here. Who are they talking about here? Citizens of the United States. Are they referring to a hierarchy? You're not wrong, by the way, but I'm pushing on this deliberately.
In a way, it's kind of in the same sense that my dad is also a brother to my uncle, But when
Dad
it
is a
comes,
brother to your uncle, yes,
yeah,
that's
like
correct.
so, my dad could also be a brother,
Yes.
but a dad has more authority,
Ah.
but he doesn't preclude
Well, you
him from
see-
being a
well, you see,
brother.
Are there different rights for citizens of the states and citizens of the United States? Is this saying that there's a class of federal rights which are separate from rights that the states can't violate?
I would say so, because if you're a citizen of the United States, you have certain laws to abide by, but sometimes the states will make ones that are more concise, I guess, with more or less.
So does this mean that the states have more power or less power into this reading?
More power than who?
Before. So you have two readings, right? Under one reading, the states can't violate certain state laws, state rights. And under the other reading, the states can't violate these federal laws. Which one's broader? Or has a slaughterhouse case defined those?
It says that the citizenship of the United States is not the same thing as the state citizenship.
But what does slaughterhouse say are the privileges or immunities of citizens of the United States? How does a slaughterhouse case define that?
It was like the well-being of a human, like day-to-day life.
Specifically, how they define it? What are some examples of some of the rights they give?
I'm not sure.
To include the right to make and enforce contracts, to sue.
Well, is that from the majority or the dissent?
That's it.
Yeah, you're into the dissent, aren't you?
But a lot of
Yeah,
the
you are.
information we gave, even when we were talking about the separation of the state and how the 13th, 14th, 15th Amendment become a new spectrum, or is a shift from that, the Bill of Rights is also from the dissent.
Yeah. So, Adiyami perhaps sees where I'm going with this, right? This is one of those cases that virtually everyone agrees was wrong. Left, right, middle, center, doesn't matter where you are. Virtually everyone agrees that this case was wrongly decided. And just to read the majority and to read the dissent tells you that something's off, right? So let's go back to the question that I began class with at the outset, right? Jessica, what's the problem with the majority's reading that this was only affecting Freedmen and we don't want to read anything past it? Why is that such a difficult conclusion to reach once you look at the dissent? Well, why is it such a tough conclusion to reach?
Well, the majority says that the 14th Amendment privileges and immunities clause is just for the citizens of the United States, whereas the dissent is for.
But why does the dissent have, I think, what's a fairly compelling case that the amendments are broader than just giving rights to freedmen? Why?
Well, I know it makes the argument that if they could, let the corporation have this monopoly, that should also be allowed for private citizens, like they should have the same rights.
Well, let's look at this monopoly for a minute, right? Let's look at the monopoly. Okay. Why would a monopoly be unconstitutional, right? What's the effect on the people of New Orleans, the butchers of New Orleans, which is with this monopoly? What effect does it have?
Why would it be unconstitutional?
Yeah, why would a monopoly be unconstitutional? What about it? Assuming the dissent is right, what about a monopoly is unconstitutional? What right is this monopoly violating?
The right to make a living.
What is this right to make a living? Where do you get this from? Why is this a right? I don't say it the same way.
It's not.
So why is this a right? He's not listening. How do you know it exists? I think think you're right, you're correct. Why would a monopoly that says you have to go to this one butcher house be unconstitutional, say it violates the right to earn a living, right? Where does this right come from?
It doesn't mention that.
It doesn't. So where does it come from?
So the rights are not limited, just the rights.
Andre, take a step.
It affects interstate commerce.
This has nothing to do with Congress. This has nothing to do with Congress. This is state law. Commerce clause only applies to states.
Well, the Sherman Antitrust Act.
No, it hasn't been enacted yet.
It
It has not been enacted yet. You're a few decades early, my friend. Jonathan, why is monopoly unconstitutional? Why could it be? What's Justice Field's argument dissent?
So you can infer the right from just being free.
What evidence do we have that this right of contract is protected by the Constitution? What evidence? And you can even talk about Thomas's dissent as well, McDonald. They're one of the same. But where do we get this from?
You're talking about the right to pursue a calling.
The right to pursue a calling. And how does the monopoly interfere with this right to pursue a calling?
It's something the butchers could do before, but now they get it to.
I like where he's going with this, right. This was a living, a profession. If you were a butcher before this law, you could run your own butcher shop. But after this law, you couldn't. You now have to go to this other place and pay them a part of your fee. And by the way, paying that fee was not small. It took out your own life savings and your own income. But the answer that I'm looking for, is I think most of you are tap dancing around, is the right to earn a living one of the privileges or immunities of citizenship, right? Is this right of contract, you may call it, one of these privileges or immunities of citizenship? The dissent says absolutely. The majority says absolutely not. Right? Elizabeth, so let me ask this question again. How does the majority define the privileges or immunities of citizenship? How does the majority of the slaughterhouse define those?
Honestly, on the page numbers, I thought we were only supposed to read the dissent, so I didn't read the majority of the
Zach, you got it? Case?
I'll read the dissent as well.
It did say that.
Okay. Then I'll help you out. The majority, anyone read the majority by chance?
Part of it.
You want to give a stab?
The part that I read.
Yeah. Anyone want to take a stab at the answer? How is the Amber?
I think it was access to ports and waterways.
Yes.
And the right to run for federal office and certain rights affecting safety on the sea.
Okay, very good. That was actually the passion I'm looking for. It wasn't that significant. That was the passion I'm looking for. The majority defined the privileges or immunities of citizenship as a narrow body of rights. A narrow body of rights affecting only certain federal issues, such as, what was it, accessing the seaports, right? Protection on the high seas, petitioning the government, visiting the sub-treasuries of the United States. If these sound very silly and trivial, you're right. He lists basically irrelevant items. So, for example, if the state denies your ability to access the sub-treasury in Washington, D.C., the state has violated the Privileges or Immunities Clause. Does anyone think that that is conceivably a correct interpretation of the clause? That we fought a civil war and ratified an amendment so that the state could make sure you get to the sub-treasury, and that the states can make sure you have protection in the high seas? Amber, what do you think? No, of course not. It's insane, right? The majority defines the privileges or immunities of citizenship so narrowly that it basically reads the clause out of the Constitution. After this case, the Privileges or Immunities Clause became a dead letter. It had zero impact. It had no significance. And this was designed to be the crowning jewel of the 14th Amendment. This was like the big deal. We talk about equal protection, due process, this was it. This was what the framers really had thoughts about. It came first, it was very significant. But the majority reads it in such a narrow and cramped fashion, such as to render it into oblivion. It has no weight after this. You can say it was strangled in its crib, right? It was only 5 years old. And the Supreme Court said, we're not going to do this. What?
Oh, I'm sorry, I'm thinking like, this is such a horrible metaphor. Strangled in his crib.
Well, it was a baby. It was 5 years old.
It's so sad.
Fair enough. I'll think about it for next time I say it
Yeah.
again.
Like I'm thinking of my 20-year-old, like, oh my god.
Well,
I get what you mean though.
you get the
Yeah, I
thank
get the
you.
point.
Sorry to Elizabeth, back to
It was
you.
pretty dramatic.
So you read the dissent? All right, so tell me about Justice Field. How does Justice Field respond to the majority opinion?
Basically, he said that monopolies are an invasion of privileges, immunities, because in which citizens with private property.
Well, you're right, but does Justice Field agree that these privileges or immunities are limited to this narrow scope of federal rights, like accessing the seaports and other silly things? Why does he think that interpretation is simply not sustainable? Why does Field think that that simply has to be wrong? Zach?
Well, he thinks these rights are like the natural and
Oh, what are natural rights? What are we talking about here? Use a phrase.
the pursuit of happiness.
Okay, where do we get that from?
Property.
Property? Where do we get that from? Right? Why is property this natural right?
That's where through the whole Constitution. That's where they derive their rights. That's where everything started.
What's a natural right, Zach? Use the phrase. Give me tell me what it means.
A natural right is the right that everyone's born with, no matter.
Born with it, right? Okay, so you want to take a stab. How does Field define these privileges or immunities? Where is he? What's he looking to? How does he give meaning to this phrase?
He just uses the word natural and inalienable rights, which belong to all citizens. It basically says he doesn't really define them as much as he just assumes that. He says Congress just assumed that.
What are some of the pieces of evidence he looks to define the privileges or immunities? There's some evidence, contemporary evidence from that time period. What does he look to?
The Civil Rights Act?
Of what year? There's several. You're right. There's several which we'll study.
Not seeing.
1866. Okay, that's fine. What about the Civil Rights Act of 1866 is relevant?
It stated some of the rights.
Yeah, list them. Read them for us, please.
They can force contracts to sue, be parties, and give evidence to inherit, purchase, lease, sell, hold, and convey real and personal property
Keep going.
to the full and equal benefit of all laws and proceedings for the security of persons and property.
All right. So the Civil Rights Act of 1866, to give you the background, was enacted after the conclusion of the Civil War. At the time, the Congress was controlled by Republicans, and they said we need to pass a statute to give protections. And it listed a number of rights that were protected: making and enforcing contracts, suing, giving evidence, inheriting property, conveying real and personal property, etc. One aspect of Jim Crow that you probably never gave much thought is that even after the 13th Amendment, the freedmen were not allowed to own property. They were not allowed to make contracts. They were allowed to testify in court. Now try running a business of any sort if you can't make contracts, own property, give evidence, right? It's impossible. So what this statute was trying to do was to give full attributes of citizenship to the freedmen. During the ratification of the 14th Amendment, when people were discussing this, what privileges or immunities are, they referenced back to this act, the Civil Rights Act of 1866. They specifically referenced it as evidence of what are the sorts of rights that were designed to be protected. Now, President Johnson, who was a Democrat, vetoed the Civil Rights Act of 66. The radical Republicans overrode his veto, but they understood something. Eventually, the Southerners would be allowed back into Congress, and they would try to get rid of the statute. So he decided we need an amendment. We need to wire this into the Constitution. So in many respects, the 14th Amendment was designed to make permanent what was in the Civil Rights Act of 1866, right? Because if you have a statute, statutes can be repealed. You can repeal a statute. It's really hard to repeal an amendment. They said, let's take what was in this statute and let's bake it, hardwire it into the Constitution. So what Justice Field says, and also Justice Thomas, later McDonald, is that the way to read the 14th Amendment, and specifically the way to read this phrase, privileges or immunities, is against the backdrop of the Civil Rights Act of 66, right? So the sorts of rights that they list here, and Case read them very well a minute ago, those are the sorts of rights. So when I asked a few minutes ago, I think it was Andre or someone, how do we know what these rights are? Well, the drafters told us, look to the Civil Rights Act of 66. But it wasn't just Civil Rights Act of 66, right? Carla, what other sources, right? What might some of these other rights be in the Privileges or Immunities Clause? What, I mean, we have a pretty good list at our disposal. What other rights might there be included in this? And Thomas, this is more Thomas's point, but I'll mention it here. What are some of the rights that, if you read Thomas's dissent in a concurring opinion of McDonald, right? We'll come back to Bradwell, I promise, but I'm asking this question here. What are some of the rights that might be included here?
Life, liberty, and the right to acquire and possess property of every kind.
You're right. But what other body of rights should be included within this category?
Privileges and immunities designated are those which...
No, you stop reading, look at me. What other rights, we have a lot of rights that might be disclosable, might have been intended to be put within this category? Beyond the Civil Rights Act of 66, what body of rights? Kevin?
Is this going to be found in Cornfield v. Forums?
Well, there's Corfield v. Coriel, right, which lists the rights to make contracts and other rights, but makes something very specific. What did the framers, this is Thomas's point, understand? The first 8 amendments. I do this all the time, like killing. Kevin, what's the answer? Yes. The wind-up was so good and I struck out. By the way, I know the game started, it starts in a couple minutes. Please don't check the scores. So pay attention. The Astros game starts in a couple minutes, so please don't check the scores. Pay attention to class. Yes, that's the wind-up. So the frame, I do this all the time, I break it. The framers of the Privileges or Immunities Clause, I'm so mad at myself right now. The framers, you've got an invention, another minute or two. The framers of the Privileges or Immunities Clause use this general language to refer to a lot of different things. They refer to the Civil Rights Act of 66, this business of making and enforcing contracts. But they also refer to Corfield v. Coriel, this was a decision that Kevin mentioned, but they also refer to the Bill of Rights, the first 8 amendments. And there was a general understanding among at least some of the members that among these privileges or immunities were the right to keep and bear arms, the right to free speech, protection against unreasonable searches and seizures, right? The First Amendment says Congress shall make no law abridging the freedom of speech. That is only applied to Congress. But now, according to at least some of the drafters, it would apply to the states. So if the states wanted to deprive someone of the right to bear arms, they couldn't. If the states wanted to deprive someone of the right to free speech, They couldn't. I mean, you don't think about this, but imagine trying to run an abolitionist newspaper in South Carolina in the 1870s, right? They'd shut you down. Shut down the freedom of the press. So at least some of the draftsmen of the 14th Amendment understood privileges or immunities to be not only Civil Rights Act of 66, not only corporal v. Coriel, but also the first 8 amendments, or at least most of them. I don't think the establishment, this is a field, I don't think the establishment clause can be incorporated. And I say the 8 amendments, by the way, because the 9th Amendment and the 10th Amendment aren't actually provisions of rights. They're canons of construction. So at least the first 8 amendments. Right? So Justice Field, in dissent, saying, look, if the entire 14th Amendment was meant to protect this this small category of rights, access to the treasuries, whatever, it would have been a vain and idle enactment, right? We didn't fight a bloody civil war, he says, for this trivial collection of rights. We fought it for something much greater. There was a case after this, which I didn't assign. Did anyone read it, Cruikshank? I'll briefly give the facts of this case. This is a horrible case. I don't assign it because it doesn't really teach much, but the facts of this case are awful. During Reconstruction, there was a parish, I think somewhere in Louisiana, I think it was Colfax, and there was an election for sheriff, and there was a dispute over who won. So there was one guy who was an African American, a Republican, who said he won the election. And there was another guy, a Democrat, a white guy, who said he won the election. And those sorts of disputes were not resolved peacefully. So basically, there were mobs, effectively the KKK, they weren't called that, but the same idea, started lynching people. So then all the freedmen took refuge in a courthouse in the center of the town. The courthouse was then surrounded by this lynch mob, which was basically government officials. They killed everyone inside, about 130 people. They started shooting anyone who ran out, and they lit the building on fire. And the people burned to their death. It's a horrible, horrible incident. A U.S. attorney sought an indictment against these officials, and they said that they violated their rights. And what were the rights they violated? Rights of peaceful assembly and rights to bear arms, right? They were basically disarming the freedmen. The Supreme Court, citing Slaughterhouse, said, no. The right to bear arms does not apply to the states. The states can deprive you of arms, and there's no problem with that. The trial court actually ruled and allowed a conviction. So these guys were convicted in the trial court. The Supreme Court reversed. And the Supreme Court said, because the Second Amendment doesn't apply to the states, these people, even though they were depriving the freedmen of their arms, were allowed to go free. Thomas mentions, I think, in his dissent. So one of the consequences of reading the Privileges or Immunities Clause so narrowly is that it allowed the states to violate the rights of their people, freedmen and otherwise, without any restrictions, right? So now the states could deprive any rights, and they could not seek any refuge in court. Now, had Justice Field prevailed, I think Cruikshank would have had to come out differently, because in fact they were depriving their own people of the right to bear arms. By the way, outside of militia. We'll get back there later perhaps. But they were depriving of these rights. But Field lost. And as a result of Slaughterhouse, I won't use the crib metaphor, but the court read this clause so narrowly as to give it basically no meaning. And in no small measure, we're not returning to this clause. We're done with it. After today, I probably won't mention it again. Instead, the remainder of this course, at least the next 4 weeks or so, will be on this provision, the Due Process Clause, right, the 14th Amendment, which says, nor shall any state deprive any person of life, liberty, or property without due process of law. Right? We already have a due process clause in the Fifth Amendment, but that binds Congress. This provision says states can't deprive people of due process of law. But a funny thing happened, and this is Thomas's dissent in McDonald. Eventually, the Supreme Court got around saying, well, the Bill of Rights does apply to the states. Right? The state can't, search your house without a warrant. And the state can't, shut down a newspaper, violating freedom of the press. But they didn't use the Privileges or Immunities Clause. Instead, they shifted to the next provision. They said that among the liberty interests, right, this word liberty here, among the liberty interests protected by the 14th Amendment are the provisions of the Bill of Rights. They didn't get there all at once, they got there gradually, one at a time. But eventually they said that the provisions of the Bill of Rights are liberty. And as a result, states cannot deprive you of those rights. So we'll talk about this later, we'll come back to it. But I want you guys to realize the reason why the court turned to the Due Process Clause was precisely because of Slaughterhouse and the decision to basically nullify the Privileges or Immunities Clause. Right? Because of Slaughterhouse, they had to turn to this other provision, which was never designed to bear this weight. Right? The notion that the Due Process Clause protects anything beyond process is debatable. That was not the true purpose. But Slaughterhouse required the judges get creative. And despite Slaughterhouse being totally wrong, the court has never overturned it. Never overturned it. In fact, Justice Thomas was the only justice in McDonald willing to revisit this precedent, which was an awful decision. And I don't say this often, but it's really wrong, right? It got it quite wrong, but the court has never addressed it. There are other wrong cases like Plessy, whatever, which the court has seen fit to reverse. This case was never touched. Okay? Is everything okay?
Oh, yeah, my son was calling me. He wasn't sure if he was going to take the bus today.
Oh, okay.
Don't want to leave him stranded at school, but thank you for asking.
Okay, good. All right, yeah.
Maybe I missed it. Why was the majority view so narrow? And
Well, you tell me. That was actually my next question. So I think you're kind of back, welcome back to where David got skipped for a minute, right? Adam, why? Why do you think the majority was so keen on reading the provision in such a limited fashion?
knee-jerk reaction would be that, they were unhappy about the last decade or so.
What were they unhappy about? What do you mean? Give me a little bit more.
Abolishing slavery and the South losing. But
Well, let me ask you this question this way. I mentioned the Crookshank case a minute ago with the Colfax massacre where people were burned alive, right? Now what the court basically said is the state's police power is not going to be controlled by the federal government. What do you think would have happened, Adam, if the Supreme Court held that yes, the southern states, which were basically implementing Jim Crow by the day, are now going to be shut down by the federal courts? What do you think the consequence of that decision would have been? That now Jim Crow would be curtailed by the judiciary?
already lost, so I'm not sure.
Oh, they lost, but they didn't. How do you think the southern states would react to these rulings from courts telling them how to manage their police power and manage their affairs? There's a theme we'll hit later in the semester, but what's the
Second revolution.
Or what would they have done to the judgments? Everybody already said. Yeah, I don't have an answer to this question, but I think Adam's on the right track. Had the court given the 13th and 14th and 15th Amendments their full scope, it would have severely impeded what we came to know as Jim Crow. Right? It would have made it really tough to implement this institution, which endured for 70, 80 years. There may have been a fear on the court that if the judiciary is getting involved in every single civil rights dispute in the South, that the court may simply be ignored. And the Southerners would do what they want. Maybe a second revolution. I don't know. I mean, it's not beyond their own possibility. I think everyone has something? Okay, cool. But I think the answer in part has to do with what role did the court want for itself? Did it want to be involved in all these little disputes, right? When these poor people were lynched and burned alive in the Colfax massacre, right? The Supreme Court said, no, we're not going to touch this. This is not us. This is on you, Louisiana, right? Again, there was a conviction in the trial court. The conviction was in the trial court, but the conviction was reversed on appeal.
Well, then that begs the question, how come in the last, 150 years that the courts never overturned this or at least broadened their view of the...
Well, that's McDonald, right? David, why do you think the court has never really bothered to overturn Slaughterhouse? You read McDonald, Justice Thomas' opinion, he makes the case. Why do you think they haven't bothered to overturn it?
I think other
case, I mean, they've applied, I guess, the due process, like,
Good.
other cases, I guess, it's
Yeah.
kind of, I guess, circumvented the issue of directly overturning.
Yeah. So I think David's right. I think David's right. The court has more or less done what was supposed to be done by the Due Process Clause, right? They've applied virtually the entire Bill of Rights to the states. A few provisions have not been incorporated. So the Third Amendment, the quartering of troops, has not been incorporated. Having unanimous jury verdict. I think in Oregon and Louisiana, I'm right, you can actually have a conviction in criminal court with a less unanimous jury. Right? So in most states you need 12 to convict. But I think in Oregon and Louisiana, the other one, and for certain crimes you have less than a unanimous conviction, right? But generally speaking, the Bill of Rights has been incorporated. Oh, grand jury indictment, right? Some states do not require grand jury indictments. You can have a criminal proceeding proceed on what's called information, which is basically the prosecutor submits a letter to the court saying, I think you can proceed. So there are a couple of aspects of the Bill of Rights that have never been incorporated, but they mostly have. So I think David's right, they didn't need to. One other wrinkle, this came up when McDonald's argued, did a lot of work on this case. The Due Process Clause applies to all persons. Evan, who does the Privileges or Immunities Clause apply to?
According to Justice Thomas?
No, according to the text, right there, read it.
To citizens of the United States. Or to,
Are non-citizens protected by the Constitution? Oh. Are non-citizens in the United States protected by the Bill of Rights? Whatever answer you give me is going to be wrong. The answer is depends. Some aspects of the Bill of Rights apply to non-citizens, some don't. So for example, if you are not a citizen and you're visiting in the United States, or you're whatever, you're here, if you get pulled over, you get your Miranda warnings. You do. If you're arrested and you're sent to jail, you get a right to an attorney, government-provided attorney. If you are here illegally and the police want to search your house, they need a warrant. After that, it gets a little fuzzier. If you want to own a firearm, the Second Amendment has been held to not protect non-citizens. If you want to make campaign contributions and you're not a U.S. citizen, good luck with that. You can't do it. If you want to run a newspaper and work for a newspaper, you're probably protected there. So the answer is fuzzy. But if we start saying that due process is wrong, go to PRI, you can't protect non-citizens. Right? It says it right there. So I think it was either Sotomayor, I was actually at the arguments in this case. This was one of my first cases I ever went to the Supreme Court. I waited for McDonald overnight. It was freezing, raining, cold. But I spent the night camping out on the sidewalk to get seats, and I was exhausted. It was so cold that night. But one of the arguments was, well, you know, if we apply it through privileges or immunities, do citizens get lawyers? Do non-citizens get lawyers? So there was a fear about shifting it over. But Thomas at least said, this is wrong, let's just get it right. Okay. So question mark, your hand's twitching.
So I think that
I don't know if it's a hand or a finger, you know.
That's a condition.
Yeah.
I think there is a difference between a privilege and a right. And the ones that you just
How do you
listed,
define privilege, my friend? I didn't mean like that. How do you define privilege or immunity?
I mean, anybody who's ever been yelled at by their mother says, you know, that's a privilege that I provide you with, and I can take it away from you. Whereas a right is something that cannot be taken away.
Now, what if I were to tell you that in the 1800s the word maybe had a different meaning than it does today?
Then I would believe that, because it's, to me it's
But isn't that Justice Thomas's argument though, right? That this phrase had a meaning as like a term of art, and that people in the 1800s knew what it meant. And it's not the same way your mom used it. God, you know, bless your mom, but she perhaps didn't use it the same way that John Bingham and the others used it 840 something years ago, right?
But like for like a non-citizen to have a gun, I mean, that's a privilege that could be taken away. But his right to be treated, her right to be treated like a human being while in our country, that's a human right.
A human right? What are these human rights? You know where you're going with this one. Where do we get these from? How do you know what those are?
The Bill of Rights.
Bill of Rights says person. Doesn't say anything about a citizen.
So the Articles
of Confederation?
The Articles of the Constitution.
Doesn't speak of citizenship. In fact, until the 14th Amendment, there's basically no concept of citizenship in the Constitution. It doesn't really exist.
Well, what else would we, the people of the United States, mean?
Who are the people? Who are the people in the body politic?
I don't
I'll ask you
know,
another
that's
question.
white men.
Does the Fourth Amendment apply outside the United States? If a bullet is fired across the Texas-Mexico border and it strikes a person on the other side of the border, is that an unlawful seizure? That was at the Supreme Court last year. Exact case. U.S. agent fires a bullet, goes across the border, right across Texas, right to Mexico. If a U.S. agent shot someone in the United States, you can bring suit under the Fourth Amendment for a seizure of your body. The bullet crosses the border. Can a person in Mexico claim the Fourth Amendment rights? A U.S. agent crosses a border and does an illegal search of someone's car on the Mexican side of the border. They find drugs. Of a person who's not a U.S. citizen. Does the Fourth Amendment apply there? Does the Fourth Amendment protect only people in the United States or outside? You want an answer, don't you? I don't have one for you. The Supreme Court actually wasn't able to resolve that question. They basically punted on it last year. About the bullet, the border shooting. We'll see. Maybe we get a decision again.
So the question is whether or not.
Well, what are the scope of rights? Do they apply internally to citizens? Do they apply to people outside the United States? Does the Bill of Rights apply if you're a U.S. service member in a base in Japan? Do you have to get a jury trial if you're on a base in Japan, a U.S. military base?
No, because you have special military laws.
Oh, okay. But the Bill of Rights applies there as well. You're a civilian on the base.
Oh, if you're a civilian.
Yeah, Kevin.
What about a military draft?
What about a draft?
Where the U.S. government says you're going to have to come serve our country now, even though you have a good
What's
job.
the problem with the draft? Why would that be problematic?
Well, wouldn't that be taking away the person's rights to...
Which provision of the Constitution would the draft most directly affect? Far more than the 14th Amendment. What's that?
Involuntary servitude.
13th, yeah. So when the draft was instituted during World War I, there was litigation about whether it violates the 13th Amendment, which reflects an imposition of involuntary servitude. Right? Does putting someone in the service against their will amount to slavery? The courts rejected that. It's not a trivial challenge, though. Yeah, David?
Would that be like the situation where, like, in times of war, the laws are kind
Oh, thank you. So in times of law, the wars fall silent, right? That's that maxim we discussed a few weeks ago. If the government couldn't impose a draft and we were getting destroyed by a foreign nation, you know, what happens then? And people aren't enlisting. So, to summarize this little discourse up, the nature of what rights are and defining what they are is very difficult. The first half of our course was basically about structure, right? Separation of powers, Commerce Clause, necessary and proper, right? What are the structural constraints on the Constitution? The second half of our course, which basically begins today, which is perfect, is what we call rights or liberties, and how to define the rights and liberties. Who do they apply to? How do courts balance them? It's a very different inquiry. You'll find the second half of the class is very different than the first half. They're both important. You'll need to know both of them for your exam and your bar. But it's a very different approach to how to think about things, because it's not about structure anymore. Okay. All right. Any other questions on slaughterhouse? I think we've butchered that case to death. Sorry. When this case was argued in 2010 or 11, I made so many awful butcher puns. It was a terrible year for me. It was embarrassing. Anything else on slaughterhouse? All right. Let's go on to the next case, Bradwell, which I know is a case that people get very upset about. Am I right? Yeah. So this is a case that was actually decided, I think it was on the same day as Slaughterhouse. Okay, it was a case decided on the same day as Slaughterhouse. I guess Amber.
Yeah, because I was wondering the dates
were like 1872 for this case, but then 1873 in the book for
These are tacos.
slaughterhouse cases.
Oh, shoot. Thank you for telling me that. So I need to correct that because I'm gonna send those to my publisher immediately after class. The third edition has not yet gone to press, so I can still fix that. Extension. So we may have actually caught that. So the reason why, and this is something that it's a mistake that's very commonly made.
So it's 1870?
They were decided basically the same day. Yeah, I have to fix that. Here's the reason why. At the time, the Supreme Court, when they would do the citations, they would list the date it was argued instead of the date it was decided. It's a maddening thing, and people make this mistake all the time. It's almost always the year after, so I'm going to have to fix that immediately after class. I caught, thankfully you didn't, but I caught in a few other places in the textbook where this is a mistake. So, Dean Jenkins, I'm the new editor in a case book, and the third edition is coming out this spring, so I've had to fix a lot of things. And this is one thing which so Amber, very astute, gold star for today. But they were decided the same day. Very astute. Anyone else notice as well, you get your gold star as well. But they were decided the same day. I don't actually have any gold stars, but you imagine they do. They were decided the same day. And the reason why they are important is this was the first application of slaughterhouse, right? So imagine, you're Myra Bradwell, right? And your lawyers argue this case at the Supreme Court. And you're thinking, man, we got this great privileges and immunities clause, right? And then, like, you lose because of this case that hasn't been argued yet. Can you imagine how bad that must be, right? They say, okay, go back and re-argue this case in light of slaughter. It's like, okay, you lose, go home. That's basically what happened. All right, so let's do the facts here. Yeah, I think, Evan, are you next? No, I called on you. Adam, gold star. David, go. Give some facts. And no, that was very astute that you caught that, so I appreciate that. So, David, give me the facts in Bradwell, Illinois, please.
Well, in Bradwell, she was a married woman, and she was married to a lawyer.
Good.
And she learned a lot from her husband.
What do you call that when you learn with someone? It used to be the name of a reality show.
Apprentice.
Yeah, she was the apprentice. Good.
And so she wanted to get a license to practice law.
Good.
And they basically said, no, you can't.
Okay, very good. So, in some states, you actually don't need to go to law school. In Virginia, where I went, they still have what's called an apprenticeship. So if you basically, it's called reading the law. If you read with a lawyer for a certain number of years, you can sit for the bar exam. So in Virginia, every year, a handful of people actually do that. I never considered it, but I suppose I could have. Bradwell was a female, and she was married. And her husband let her work in his law office, and she read the law. And then after the requisite number of years, she applied for a license with the Illinois Supreme Court. And she requested to be seated for the bar. Okay? Now, before the 14th Amendment, she would have been out of luck. She would have had no claim whatsoever. So, David, what was her argument that she should be allowed to sit and be admitted to the bar?
Well, because she was a citizen of the United States, that she should be granted all the privileges and immunities.
Very good. So she claimed that among the privileges or immunities of citizenship was the right to earn a living, right? This is the same business as the butchers, right? It's the same argument. She said, as a citizen of the United States, I have the right to earn a living. This is actually a book written about her by Jane Freedmen, so a decent book if you want to take a look. She said, I have the right to become an attorney, and you're imposing this arbitrary restraint in front of me, right? I have the number of years, I have the character, I have the fitness, everything else. Let me in. So she litigated this case based on this privileges and immunities. Now, you would think based on modern standards, you would say this is a violation of equal protection, right? You're letting men into the bar, but not allowing women into the bar. Easy, right? But again, she didn't even think to plead equal protection. Or maybe she did, but that wasn't her primary claim. Her lawyer said we have to focus on privileges or immunities. Okay? So Aaron, what happened? How did the court treat her claim?
The court would like to know.
What was it like to know? Thank you. That's very astute. Yes, sir. You want to give me a little bit more? Yeah, no.
It depended on the state, and it wasn't protected by the 14th Amendment.
Okay, good.
For the state to decide.
So what the court basically said, this is the majority case. Look, we just decided slaughterhouse a few minutes ago, right? The scope of rights protected by the privileges or immunities clause are very narrow. It attaches only to this subset of federal rights. It does not include the right to earn a living. It does not include the right of contracting. So therefore, the state, Illinois, is free to violate this provision. Right? So the majority opinion by Justice Miller is pretty breezy, right? It's really short. You probably love reading. It's like, man, this is short. Because it follows naturally from slaughterhouse. If the butchers don't have the right to earn a living, then neither do women. So that's the majority opinion, right? Boone, tell us about Justice Bradley. Concurring opinion. Now, Bradley dissented in slaughterhouse, right? Bradley said that the butchers have this right. How does Bradley then square that and say, well, the butchers have the right, but the female lawyers do not?
Because of the differences.
Yeah, well, walk us through the opinion, please. Thank you.
He says that they need to stick to the respective spheres of their destinies, and then he says the female sex evidently unfits it for many of the occupations of civil life. He says they're supposed to be wives and mothers, and he says a domestic sphere. What else?
That's enough, okay? So, I think we get the picture. But the question is, why? Hold on. Why does he go out of his way to do this, right? Jason, why does he go out of his way to make all these points, right? Why is it necessary to go through this entire litany to discuss all these various things? Why does he need to do this?
To make sure that there's a distinction that women are not protected.
But why does he, Bradley, why does he particularly need to do this? What about his slaughterhouse opinion requires this sort of decision? Jackson, you guess that? Brittany? Why does Bradley need to do this? Or at least in his own mind. Why did he need to go through this entire litany about how women should stay in the kitchen? Right? What is his reason for doing this? Brittany, let me ask the question differently, right? If he didn't go through this entire discussion, how would someone describe his vote, right? If he didn't do this, what would someone say about Bradley as a judge? Well, reading this, it sure seems like it's against women, but what if he just joined the majority quietly, didn't write anything separate? What would the criticism be of Judge Bradley?
So he'd be contradicting himself.
He'd be a hypocrite, yeah. Because he just said a minute ago that the Privileges and Immunities Clause applies and gives all these rights of contract. How can they go around and say, oh, but not for women? So the reason why he went through this entire litany of saying women have their spheres and they should be in the kitchen and all this other stuff is because he's saying they're not protected, right? Now, look at the text. Look at the text. Always go back to the text. It says the citizens of the United States, not the male citizens, not the female citizens. So he has to concede that females are citizens. But so are children are citizens. And at the time, and did you learn about coverture in property? Yeah, so you should have. So under the laws of coverture, a married woman, right? A married woman is effectively a child, right? If you're a single woman, you can make contracts and hold property. But while you're married, you're basically treated as incompetent. You cannot hold property by yourself. You cannot make any contracts by yourself, right? What actually happens is when a woman and man get married, it creates this artificial third person, right? It's called legal fiction. And all property is deposited in this legal fiction. Now, the reason why it's called a fiction is because the man controlled it, right? In theory, it was jointly owned, but you know, the man had to supervise it. That was the institution of coverture. That's how coverture operated, right? So what Bradley's saying is we have this institution, so a child and a woman are on a similar plane. They're not able to have all the rights. So